In this video, I'm going to be talking about a common misconception that if you were falsely arrested for domestic violence has probably at least crossed your mind, at least fleetingly, and acting on it is a really bad idea for most people. This is actually part 6 in a 7-part series in which I go through the misconceptions that over the last 11 years doing domestic violence cases, I've heard time and again. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of Defeat the DVRO, a course in which I teach you from start to finish everything that you need to know to represent yourself and win your domestic violence restraining order hearing. So if you are, in addition to having been arrested, facing a restraining order, make sure that you get your free first class in the course via the link down below. Okay, so let's jump right in. The idea that if you were falsely accused of domestic violence, you were arrested, you had to bond out, has at least probably crossed your mind once, if not twice, is using your case to take a stand against the unfair way in which domestic violence arrests happen and prosecutions happen. Look, it sucks. The police come out and they'll tell you whether or not the alleged victim wants to press charges against you. They'll tell you, well, it's just our policy, it's a domestic violence call, we have to make an arrest. Sometimes they'll say something about O.J. Simpson and blame him for the fact that they have to make an arrest here. That is some department's policies. So maybe that's how you got arrested. Maybe it is a crazy jealous ex who wants to get back at you. Maybe you and your wife just had a loud argument and a neighbor called the cops. But the thing is that when you find yourself in one of these situations, you may be shocked to realize how little evidence the police require in order to make an arrest. And once they make an arrest, now you're going to jail. You have to figure out how to bond out. You have to pay, let's say your bail is $50,000. You usually have to pay $5,000 in order to get out. You never get that money back, by the way. And based on what? Right? Like what evidence did they even have in the first place? That sucks. Now you start calling around to defense attorneys and you realize this is really expensive. You know, you bonded out of jail, but now you have to hire an attorney to represent you. And it is important to hire one, even if it's your first arrest, to try to get your charges dropped before court. And that's if you can even afford to do that. And then let's say that you do go to court, your charges are not dropped before court. Now you're treated like garbage by everyone there. Maybe the bailiff yells at you. It's confusing where to go to. Everybody else is rude. It's horrible. At the very first court date, the prosecutor, some guy in a suit that you've never seen before in your life, he's never seen you before either, argues to the judge that you are a danger to society and maybe tries to get your bail raised, which would put you back in jail having to spend more money to get out. Maybe argues that you are a danger to the alleged victim, even if the alleged victim wants to be with you and isn't even there in any case, and wants to put a restraining order on you. The prosecutor will read from the police report at your first hearing, and this is true throughout the state of California. If charges are filed against you, will read from the police report, whatever they wrote in there, which you probably haven't even seen yet, as though everything in there is a fact. And there are all these people in court looking at you like you are a criminal when you know you did nothing wrong. That is enough to make anyone angry. And you may be tempted, especially if you are able to afford an attorney. And as Jay-Z once said, I got a few dollars, I can fight the case. You may be feeling like that. And you may be feeling, you know what, I want to take a stand. This is BS. This is crazy that this is the system that we are under just based on somebody's accusation. And you tell your attorney, this is a he said, she said case. They don't have anything. And your attorney informs you and shows you a jury instruction showing that you can be convicted based on the word of one person alone with no other evidence, no pictures, no medical records, no video, nothing else. You can actually be convicted. And your attorney shows you how much time you could be doing in jail or prison if you do get convicted. It's crazy, right? And so it's understandable that you may be tempted to take a stand and fight it to the bitter end. And sometimes you do have to fight the case to the end. Like I know, for example, if I were to take any kind of plea to domestic violence, I would have to answer to the state bar. I could lose my license. And so to me, it might be worth the risk to go into trial, unless they gave me a deal beforehand that was, for example, classes in exchange for a dismissal. If they offer me that, and I know that that will not mess me up with the state bar, sure, I don't want to go to classes, but rather than using myself as a pawn in the system to try to take some kind of stand, which, by the way, isn't going to teach a lesson to anybody. Your case will be over, you'll either be convicted or not, and then they'll keep doing the same thing. They're not going to change just because one person beat a DV case. I've done multiple DV trials, I've beat DV cases. It doesn't change what they do. I've shown that cops were lying on the stand, that cops bullied the alleged victim by saying that they were going to take away her kids if she didn't say that he had hit her. I've proven that on the stand, and it doesn't matter. They do the same thing. It's not an effective way, in my experience, to actually make a change. So when you are facing domestic violence charges, what you need to think about is protecting yourself, protecting your future, doing everything that you can to avoid the risk of trial. And yes, if you have to go to trial, be ready to go to trial. But if you can potentially protect your record, protect your freedom, get some kind of offer that's not going to mess you up, where you're not convicted, then you might want to take it. And one of the worst things you could do is say, no, I'm not guilty, so I don't care if it's just classes in exchange for a dismissal. I'm fighting this to the bitter end because of all the risk to you. Now, maybe you don't care. Maybe going to jail or prison isn't a big deal. Maybe it's not going to matter for your job or your future. But there's so little to gain by taking this kind of stand. And so if you can avoid it, that is what you should do. So let's do another example, as I've been doing for the other misconceptions. And we'll do a choose your own adventure style where we see where one choice could lead versus where another could lead. Alex has been falsely accused of domestic violence by his ex-girlfriend. They have no proof except for her word, but she is a rather convincing liar. He is incensed that this is the system that his taxes support, and he wants to use this case to expose the systemic flaws in the system. He gets an offer, 10 domestic violence classes, 10 anger management classes, so 20 total, in exchange for a dismissal. They cost about $25 each, and he's a busy guy. His attorney informs him that if he does not take that offer, the prosecution has said that they are going to pool it, and then the case will go to trial. So he has a choice to make. Choose your own adventure, choice number 1. He decides, absolutely not. Why should I pay all that money? Why should I waste all that time? And then they're threatening me that they're going to pool the offer and we're going to have to go to trial. They don't have any real evidence. I will take the stand if I have to, but my ex is lying, and I'm not going to give her the satisfaction of having to take classes to get rid of this wrongful arrest and prosecution in the first place. How can this be our system? And so he rejects the offer. He goes to trial. His attorney does his very best, cross-examines the alleged victim. But what he realizes once he's sitting there looking at the 12 people who are going to judge him and decide his fate is that when he's sitting there at the defendant's table, those 12 people, none of them have ever been in his position, and they are kind of assuming that he must have done something wrong. His ex gets up on the stand, she's crying, and after court, he's asking his attorney, do you think you can get that deal back on the table? Now, we're rooting for Alex, and hopefully he does get the deal back on the table, but this is often how it works with deals. They will be pulled, and the last thing you want to do is make a decision that you regret. Now, let's say Alex does decide that he is going to take those classes. He decides in choose your own adventure choice number 2, he's going to just go ahead and take the deal. He's going to do those anger management. His attorney makes sure that he can do all of them online. He's going to do his 10 domestic violence classes, and he submits his proof to his attorney. He doesn't even have to go to court to turn it in. His attorney goes and lets him know that the case has been dismissed. He's still mad about it, and in fact now he decides that he's going to start educating men about their rights and how to avoid being in that situation. Because now he's no longer defending, now he's safe. And now he can fight against the system from the outside of it. I hope that you found this video helpful. If you do have a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation there. And if you did find it helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.